So welcome to week 3. We're still on week 3? Yes, we're on week 3 for Success 4. This week, the workshop is all about the mental elements of making a will, which really is, in all practicalities, about the situations where people lack the mental elements. So wills are often made and amended by people who are elderly, who are often ill, sometimes suffering from dementia. And the most common problematic thing that happens in practice is someone wants to change a will, and what do you do about that? And how do you evidence their capacity? So the workshop exercises this week, I've kind of misjudged this particular week because I was thinking we were having a big class, and the exercise involves an actual interviewing process, and I've put up some extra resources there on some tips on interviewing and ideas around interviewing. So if you want to do the workshop for this week, it's probably a good idea to we're not going to have really the people to do it here in Zoom, but you can arrange with someone else to do it, either another student via Zoom, or you can even get a family member or friend to play the interviewee, because they don't have to have any legal knowledge. The point of it is just to run through that exercise of developing a particular style and thinking about the sort of questions you need to ask when you're interviewing a client in this area. And I've put some tips online, and I'll tell you a little bit about the sort of things that I do. And then we'll have a look at some of the things out of the textbook this week, because I think this is probably one of the areas that there is the most interesting things in the textbook. It's also the longest chapter in the book. So if you haven't finished reading it this week, you can finish reading it next week or the week after. It's a very long chapter. But there's some points I'd like to make on that. So feel free to jump in with questions anytime, or to drop in a question via the chat function, which is very useful. So yes, if you want to do the we're calling the quiz, but the reflective write-up on the workshop this week, just find someone who's willing to play the part of the interviewee. Let them figure out, whether by rolling dice or by choosing what their particular angle is, and work through a bit of a role play. Because it's one of those things we don't do enough of in the course. We don't do enough of in face-to-face law courses, and it becomes quite difficult to do when you're dealing with an online course. So I've provided some starting resources, some ideas of things to think about with interviewing. When it comes down to the practicalities of interviewing, I think the most important thing is to put the other person at ease. And the way you do that, I guess, is the first thing is that you have a little bit of a patter that you will develop over your career, with how you introduce yourself and where you are. So you say who you are, what your position in the firm is with or legal centre or wherever you are. And some people like to bring in a personal comment, or just to talk about, it's basically small talk to get started. Now, this is tricky because clients are technically paying billable hours. And if you want to sit around and talk about the footy or the weather, some clients get very kind of antsy about paying for that. So you don't want something that's going to be a long conversation, but basically you want to get them talking back to you. And that's often the hardest bit, is getting that handover from saying, this is me, I'm Scott, I'm a lawyer, I work at this community legal centre, my job is to help you work through your will. Now, how do you get them talking? Okay, so small talk is one thing, it's nice day, isn't it? Sort of thing. What I tend to do next is I would ask them about their family and get them to do a rough outline of who their family is and who's and to make a record of a sort of chart of their family, for a couple of reasons. One is, if you get straight into the will and you ask them what they want to give, you may not be aware of people who they don't want to give gifts to. You might not be aware that they might have parents that are still alive, may or may not still alive, brothers and sisters, and so on. So what I would start with is say, okay, first thing I want to do is make some records of your family for our files, so we know who's who. Can we start with your parents? What are the names of your parents? Are they still alive? Do you have a partner? I'd probably go to brothers and sisters. Do you have a partner? Do you have any ex-partners, children? And work your way through those lists. So rather than start with what do you want to give to people, I would start with just mapping that out. And there's a few reasons for that. And one of them is that, sometimes there might be a dependent in there who could probably make a challenge to the will, and you want to know that they exist. They might say, oh yeah, my son Jeff, but I hate him, we don't talk, whatever. You make a note of it and put it in. You need to be aware of those sorts of things. The other thing is, as we talked last week, the process of writing a will can be quite traumatic and people can be quite at edge. So I wouldn't myself like to start with, now think about when you're going to die. Think about all your family and how horrible they're going to feel when you're gone. I'd start with, something that is current, that is for most people positive. Some people, family isn't very positive at all, but for most people it's a bit of both, but it's a positive thing, and work through that. The next thing I'd get them to talk through is their main assets. So house, car, shares, anything that they may want to leave in the will. Now, for most people, they're going to leave all of their possessions to one person. Generally speaking, that's what the majority of wills are. Someone say, I want to leave everything to my partner, and if they die before me, I want it split between my children, or something along those lines. So that you don't need to go through and make a list of everything in the will. But again, you're talking about people. You're talking to people about something that's positive, and you're talking to them about sort of what they've. We've got aliens on the line. You're talking to them about what they've achieved in their life. So that makes the transition easier, I think, to I've got a background as a mediator too, and one of the things in mediation is some people you can't stop talking, and a lot of other people you can't get them started talking. So you set the boundaries of the conversation. I don't know if I can do anything about that, but interesting noises. Anyway, the other thing is you need a gentle but firm hand to steer people as well. Because again, especially when you've got family feuds and things in there, and someone will say, "Yeah, I do have the son Jeff. We don't talk," and then they want to tell you why, and you don't really want to. And you want to get back onto the topic. So then I get those details down first, get them talking, you get them comfortable. Then you talk about the kinds of wills that you can offer, because people may genuinely really have no idea where to start. And you can say, most commonly people will leave wills to partner or to children. I don't know if Cheryl is there, but if you are, can you mute your microphone? Because we're just getting strange feedback. I think Cheryl's iPad might be on the couch, so the cat's sitting on it or something. Or Cheryl's been taken to Twin Peaks, one of the two. Anyway. Okay, so then you talk through what their options are, and you'll then get a gauge of whether they want something that is quite simple and straightforward that you're going to be able to put together then and there, or whether it's something that they're going to have to book multiple sessions in. Because some people have multiple shares and stocks, and they want different dispositions. They want this person to have this specific stocks, this and that. What you can also do is get them to write, particularly if you're not going to finalise the will on that day, you get them to write a list of possessions. Okay, I'll see if I have manage participants. Yes. Look at that power. I can mute people. Thanks for that idea. Power. Okay, so some people will do the, well, Auntie Myrtle's engagement ring, I want to go to my niece, and those sorts of things. And sometimes those are things that they can actually create a list in their own time. Again, particularly if you're charging them billable hours, sometimes you're doing things for free, in which case your work still wants you to get it done as concisely as possible. Those are things that they can do as a list that you can then include in the will. So apart from that, the next stage, I guess, once you've got reasonably clear instructions, is to draft a rough approximation of what the will be, go through it with them again to see if that's what they want, and then you go into the drafting process. So typically, they won't be waiting for the will to be drawn up, although if you're working at a community legal centre, it might be a case of they go away and wait for half hour while you type it up for them. So the wills are different depending on where you're working and what resources people have. When they come back, you go through all the parts of the will. You make sure they understand. It's not important that they understand the legal terms, but they should understand the effect. And then once they understand, you get them to sign and date it, and you get your witnesses to sign and date it. And one of these things they never tell you, but it becomes crucial in practice. And the template I showed you actually mentions this, which is good. Use the same pen for everyone, because there's potential for dispute. If someone says everything's signed in a blue pen and this one's signed in a green pen, that these witnesses were not present at the time. I remember last week, the two witnesses have to be present at the same time witnessing the signature. And I have seen a case where it dragged on through sheer bloody mindedness, not because there was really any objective, but someone said the will's not valid because the pen colours were different. And it just dragged on and had to go actually to probate. It had to go to a hearing. And at the end of the day, it got admitted, but it was costly and time consuming for everyone. So there's just a tip for one of those weird and wonderful things they never tell you in textbooks. Use the same pen for everyone who witnesses it. So that's it. And I think this is one of those things where it's good experience to practice, and it's good experience to for the workshop this week to practice with someone who's a bit difficult, who's not necessarily going to be forthcoming, and who may not have the capacity for one reason or another to have the legal capacity to make a will. We'll talk about that in a minute, about some of those issues on legal capacity. But I think that's the and the other thing is when you're going through the will with someone, we're going to look at family provisions later on, and we're going to look at some other areas. Those can actually be a bit of a checklist for you for making sure that you have a very clear statement. So the short version of it is the family provision parts of the Act were introduced for when spiteful people who had people who depended on them decided to cut them out of the will. And particularly if they've got children and the children are not of majority, and they just say, oh, they get nothing because they're being spiteful or vindictive or whatever, and they don't have anyone to provide for them. So people who ought to have been considered under the will, whatever that means, and we've got a whole week talking about that, can make an application to the court for family provision. So when you're interviewing, you also want to check for that sort of thing, and you want to be able to say, okay, when you've made provision here under the will, you haven't mentioned your son here. Your son may be entitled to make a claim against the will. Do you want to include them? And if they say no, definitely not, whatever, you make file notes. You make sure the wording is very clear and unambiguous in the will, but you also make file notes so that if it goes to court later on, as a family provision, you can say, this is what the person said to me at the time. Or more typically, quite often it's someone who inherits the file from you years down the track, who then has to dig out the file notes and say, oh, what was going on when this happened? If someone makes a will when they're 30 and they die when they're 70, and then someone challenges the provisions under that will, you can imagine how many hands that file's been through in the meantime. Okay, so that's just some stuff around interviewing. Any questions before we move on? Make sense? Yeah, it's one of these things, as I said, practice is important. One of the best things I did as a law student in my second year was I started volunteering at a community legal centre, and I didn't get to do very much to start with. But after a few months, I was interviewing clients and taking down the particulars for the solicitor, who would then come in and say, okay, you've got the story, hand it over, and the solicitor would actually do the legal work. And that was so much more relevant and worthwhile as a learning experience than anything you could do in the classroom, which is not really an excuse. It's just the fact that real experience is so much more important. I don't know if you guys know that the CQ Law School is about to inherit the Rockhampton Community Legal Centre. Don't know if you've heard anything about that yet. But we're taking over the governance of the Rockhampton Centre, and we're basically turning it into an online practice. And keep your ears open for updates, but you'll have the potential to volunteer in that service as well. And we're hoping to tie some of that into coursework as well. So fingers crossed there's exciting things on the horizon. And yeah, even if... like I never had any aspiration to work in family law or succession law when I was a law student, and I haven't really worked in those areas, although I've prepared a lot of wills for people. But the experience, the client side experience, was something that's been valuable in other fields. Okay, so you want to talk about the mental elements of a will for a bit. As I said, the textbook. This chapter is one of the longest, and it probably has about a third of the interesting stuff in the whole course in it. The breakdown of chapters in the textbook is quite odd. Some of the chapters have almost nothing in them, and some of them are very short, and some of them that aren't necessarily short just don't have much to talk about in them. So the previous coordinator basically broke the course down by chapters, and then embedded that in our Nexus system, which has made it kind of difficult to work around, but we'll work around it nonetheless. So yeah, chapter 3 is a big one. They've actually, since the course was written, added in a chapter 4 on statutory wills, which is also relevant for this week. And I'll get you to read that as well. And as I said, don't feel overwhelmed if you've not finished chapter 3 this week, because you can finish it and then get on with the shorter chapters later on. All right, so I'm not going to go through it bit by bit. I'm going to presume you have a basic overview at least. Remember what I said about the... muted. What I said about mentioning that video about legal reading, that one of the worst things you can do if you're reading either a legal text or a case or whatever, or legislation, is to start at the start and read through to the end, because you'll probably get bogged down or distracted or kind of bored somewhere along the line. Active reading is the way to go. Skim through, make an overview, get an idea of how the chapter works, and then come back and focus in. So this is the same sort of thing. Make sure you get the overview before you dig down and look into the details. And the other thing is the quality of writing in legal texts is not brilliant, and you'll see in this one. The narrative meanders around and back and forth, and then makes a loop, and then goes off on a tangent and comes back. It's not a very structured piece of writing. One of the great hypocrisies of law lecturers that if you did something like this in an essay, we'd probably mark you down for it. But we do it all the time in the textbooks we write, because we're allowed to. Okay, so let's talk about some of the important things. Now, there's a quote or a paraphrasing on page 41 where they say, eccentricity, foolishness, spite, and capriciousness do not necessarily indicate mental incapacity. This is something that's a theme that we're going to talk about a lot in this course, is that there are two different approaches to wills that the courts take, and there's a kind of a back and forth pendulum between them. On the one hand, there's what we would generally call freedom of choice, freedom of testator choice, where the courts say, it's your money, you're a testator, it's your property, you can do what you like with it. And that was the initial position of wills. And this is what they say about capriciousness and eccentricity and foolishness, that if someone does spitefully decide to cut their family out of the will, the initial position is that the courts say, yeah, fair enough, you can do that. The other side of the coin, I guess, would be paternalism, where the courts actually intervene and change a will to produce an answer that they think is the right answer. And sometimes they do that out of a sense of justice. Sometimes they do that because they think someone's not provided for. And that family provision section I talked about before was basically introduced to as a statutory measure to allow courts to intercede where someone, leaves their 3-year-old child out of the will with no support. Or equally their 34-year-old child out of the will, although I personally have less sympathy if you're actually an adult. And we'll come to that. We'll come to those discussions when we talk about family provisions, because there is something slightly galling about someone being sort of a 45-year-old dependent saying, I'm owed something out of the will because I can't provide for myself. Or I believe I'm entitled to, whatever. Anyway, so there's those two. In that sense, when someone makes a choice that seems to be spiteful or eccentric, there's those two choices. It also comes down to principles of interpretation. Do you remember your statutory interpretation? Or is it all just a blur in the past? So you've got the literal rule and the intention rule, or they're called various other things. So when you're looking at legislation, particularly the Constitution, one thing you can do is go literally with the strict words of what the statute says. The other is the intention of what Parliament intended, taking into account changes. So the classic example of that is the right to bear arms in the American Constitution. Does that include weapons of mass destruction and automatic weapons? If you take the literal view, they just say arms, and that you just have to go with what the words say. If you take the intentional view, you then have to say, well, what did the founding fathers intend when they created the Constitution? What did they intend people would be able to do? Does that include setting up a personal arsenal in your backyard, and those sort of questions, and so on and so forth. Okay, we have that same dilemma in wills. Particularly when a mistake in a will may invalidate the will. We'll come back to that again. But if someone has written a will that, if on the strict interpretation of the will, would make it invalid, what do you do about it? Well, the old-fashioned approach was, and this is again in the freedom of will sort of approach, is you go with what they wrote, and if it screws the will and the will fails, that's what you're left with. And the courts won't do anything. The more modern view, and it's a pendulum between those two perspectives, is that the court should be able to intercede to fix the will. If we can figure out what they actually want, we should be able to fix the will. So that's a theme we're going to come back to throughout the course. May even be a theme that's on the exam, who knows? But I'll be trying to point out as we go where there are points where there are those different philosophies that come into play. Okay, so our starting point with mental capacity is that the courts will go with what originally went with whatever the testator said, regardless of whether it seemed capricious or spiteful or insane, unless they actually had proof that the person was insane. It was a matter of freedom, and you basically had to really prove that there was incapacity to invalidate those provisions. The test for the amount of help it gives us, the test from a case called Banks and Goodfellow, where it says the testator must have sound mind, memory, and understanding. This is on page 42. It sounds great, and it's like whenever they chuck reasonable man into a conversation, oh yeah, reasonable man. Sure, fair enough. Sound mind, memory, and understanding. Yep. Okay, we all have an idea of what that means. Now, like concept of reasonableness, not only are people going to have different ideas, but it's a question of then how are you going to prove those. And most of the cases that have followed have been all about that. Situations where there was doubt, how you prove it, and they've never really bettered the Banks and Goodfellow test, which doesn't leave us with a lot of concrete options as lawyers. One option, of course, is to, particularly if you have an elderly or very ill client, is to get a doctor to certify the health of the client and to interview the doctor. And I would get the doctor to put a letter on file as well. So not just because someone's sort of 70 or 80, because, you know, these days people are young into their 70s. But if someone, you really think there might be a challenge or a question later on, particularly if they're doing something that someone may have a problem with, like cutting someone out who they probably should put in, get the doctor, get a letter so you can put it on file. And some of the cases have suggested that maybe you should actually personally see the doctor as well. So you're not just taking a letter from a stranger. You should actually have a conversation with the doctor. So that's probably an individual, personal, ethical kind of thing. And I guess it also depends on the nature of the estate. If you've got someone who has, you know, two kids and they're leaving all the stuff to their kids, you're probably not going to bother that much, because no one's going to be. There doesn't seem to be anyone who's going to be challenging that will. But someone who has two kids who they totally disinherit one and leave all their assets to the other one, it may be worth taking that extra step and getting that small extra cost of having the doctor's letter on file. Okay, so we've been on sound mind. There was a relatively recent case, which is the Griffith case. By recent, I mean Justice Kirby was on it, so that's probably not all that recent, given he's been retired for so long. This is an example of that balance between freedom and paternalism. The majority in that case, it was a Court of Appeal case, felt that the testator, who had basically cut her son, I think, out of the will because he'd become religious and she had religion. So she said, I'm cutting you out of the will. She cut him out of the will. And the two judges in majority basically said there was no rational ground to cut him out and he should be entitled to the will. Justice Kirby, as was President Kirby at the time, strangely enough for him, went not for paternalism, but went for the old-fashioned kind of, well, her will was her will and it should stand. It should go as she intended, and the court shouldn't interfere. So there's an example of a situation where the courts in recent times have had to overtly talk about those two different philosophies, and there's no clear. I mean, it's 2-1, so technically the case is on the paternalistic side, but 2-1 is not the most solid of authorities there. Okay, questions so far? I've been rabbiting on a lot, I know. So feel free to jump in if you've got questions. There's a little section on lucid intervals. Okay, question 40, page 48, proof of incapacity. This is the important stuff, and here they discuss the balance of proof and the standard of proof. So that stuff's always important. As you would expect, the presumption is that wills are valid, and if you are saying that the person lacked capacity, it's up to you to prove it. That's exactly as you usually think it should be. And that's if the will is on the face of it, the will is rational. And again, we're not much further from the Griffith case, where if you take Kirby's perspective, the will was rational. She said, I don't like my son. I don't like that he's taken this religious life. I'm cutting out the will. Kirby says that's rational. People do have fights. They do have very serious fights with their family. The other two judges said, well, that's quite irrational. Who'd cut their son out of a will? Yeah. I don't think it's all that clear cut. And I would imagine it's on every individual case, it's going to individual trial judges will have different opinions. So we're not really in the world of precedent here. We've basically got two sets of opinions, which both boil down to it depends. And the extremes will probably be clear. So in some cases, you'll have a will that is on the face of it kind of wacky, in which case you're probably going to have a harder time proving it. Or you've got wills that seem perfectly rational, in which case you've got a really uphill battle saying that it should be that the person lacked capacity to make it.
I don't understand the contradiction in some of the rulings that have taken place in regards to proof of capacity. Some of them are actually quite bizarre. You look at suicide, for example, in the Hodges case. There's no actual presumption of incapacity even after suicide. I mean, to me, I don't really agree with that myself. I think that there's some sort of logic to suggest that maybe they weren't of sound mind, and yet if there's no sort of like presumption, then where's the benchmark? How do you test it? There's nothing you can do to sort of like raise the issue after that. I mean, it'd be easy if you had a presumption of incapacity. It'd make it fair, wouldn't it?
I think that probably the overriding principle for the policy is it would make everything slower. So they've gone, what's the best way to expedite the process, and then said, we'll presume capacity and then look for signs of incapacity. Now, the suicide one, I think it was pretty close on the making of the will, but there's also that elapsing of time between making the will and then something which might prove incapacity that becomes really troubling as well. So someone does something that seems really crazy. How long after the making of a will do they do that? Do you decide that that's proof of incapacity? I don't have a really good answer to that myself.
No, it's just, to me, it's almost as if like it's so vague. It really shouldn't be a presumption. There shouldn't be no presumption. There should definitely be a presumption. I mean, I can't understand how they can't have a presumption, because to me it's so clear cut. But I don't know. That's just me, I guess. I don't know. It seems weird to me. That's all. I don't really I can't understand the logic behind it.
I guess they're presuming in favour of validity, because they'd rather make a will valid than invalid. So you go for the thing that makes the will valid rather than constantly go to intestacy. And also, like, this is the problem with law cases and reading law cases. One of the many problems is you really don't get all the facts, and you don't really get what a trial judge sees or the evidence a trial judge sees to differentiate between these.
Yes.
So when someone says there's evidence someone suffered from dementia, and that's in an appeal case, that could mean anything. And if you're actually in the court at the principal hearing, you'd probably have reports from doctors and from family friends and things that would say what kind of dementia. And without that, it could be they're a bit forgetful and they wander off, sometimes dementia, or it could be really, really serious sort of harm to self and others kind of dementia. And you don't get that at all with the way we look at where appeal cases are reported. So it makes it very, very tricky. But what they say, we go what they say. The presumption is that you have capacity, unless there's something on the face of it that looks very strange. And you think, well, if it looked really strange, what kind of solicitor wrote that up? Or maybe it wasn't written up by a solicitor, and I suppose it could be a valid will they wrote themselves. Fair enough. That could look very strange. But most of the time, if you've got a professional helping you write up a will, it's not on the face of it going to look irrational, I don't think. Which is why in the Griffith case, the two majority judges said, oh, well, it's irrational to leave your son out of a will. She was 80, her son was 60. Is it irrational to leave your son out of a will? And I'm leaving that as a hanging open question because I don't have an answer to that. Okay. So there's a little bit of discussion in there on what sort of evidence you need to prove. There's an interesting enigmatic comment on page 50. There's a comment from Windia about evidence from psychiatric evidence by experts who have never seen the deceased during their life is of little use in the circumstances. And His Honour preferred lay evidence from conversations, family members, and people who are actually treating doctors, people who actually knew the deceased. So that indicates to me that people are going to court with psychiatric evaluations post-mortem of people that they're producing as proof of incapacity. And that just seems bizarre to me as well. But it's obviously happening because for Windia to actually make a comment like that and to point out that he thinks that it's a waste of time doing it, it must mean that people do that. So a lot of legal cases can get pretty nasty, but I just can't imagine a probate case where you've got both parties hiring psychiatrists to produce psychiatric reports on the basis of circumstantial evidence of a client who they've never actually spoken to or seen, both coming to a contrary opinion of whether the person had capacity or not. That just seems very strange to me. Anyway, there's a bit of stuff on timing in there, which is again is that bizarro cases where someone gives instructions to create a will. The person goes away and writes the will. Something happens in the meantime and they lack capacity, which is the time at which you have to test capacity, when they sign the will or when they give instructions. The answer is, I think surprisingly, it's when they give instructions, not when they sign the will. So again, it's probably an example of where the courts are trying their best to uphold a will's validity rather than strike one down. Okay, some stuff on reading over the will and whether people are presumed to know what's in the will when you read it over to them. And of course, in the past, I say this hopefully, in the past, wills were more esoteric and they were the classic kind of bizarre legal document with the hereforth, wherewithin we're under kind of terms. And they would read them to clients and say, do you understand? And they'd say yes, and they'd sign them. And there's precedent that says you don't have to actually understand it, but you just have to kind of understand what the will does. These days, with plain English drafting, there's no excuse for them to really, I don't think, to not understand pretty much the whole thing. Maybe if you're setting up trusts, you might say they don't have to understand all the ins and outs of how trusts operate. Maybe that's fair enough. But I think they should. A will should be written in a format that a lay person could read and understand. There's stuff in there too, because we then move on to from capacity to undue influence and suspicious circumstances, which is sort of mental capacity. I don't know. It's just sort of a very abrupt jump in the chapter. So you're familiar with undue influence and fraud from contract and other areas, equity, I guess, criminal law for that matter. There's also that they come into play here in a slightly different version that they do in contract law, because obviously in contract law you can generally talk to the people who sign the contract. You can't with wills. There's also an additional thing called suspicious circumstances. And this is where the expression they use is excites the suspicion of the court, where there's something where there are suspicious circumstances and that you need that there's a presumption of invalidity. And that's really limited to when things like you draw, the solicitor gets everything under the will. Those are primarily, it's where the person who's drafting the will gets everything. and that's where those suspicious circumstances are raised. So there's a case in there, Winkle and Nye. I don't think it happens very often. The only thing I think is important to mention there is that that's actually different to fraud and undue influence. It's a different area of authority. For what it's worth. When was the last time it was used? 1972. I know there's some more recent cases on that. But yeah, it's generally the case. It's the case where whoever wrote the will suddenly mysteriously gets everything under the will, and you have to then have a strong standard of proof to prove that that wasn't suspicious. Now on to undue influence and fraud. Undue influence has to be really quite nasty coercion. You would have hit undue influence in contract, and it is a little more lenient there. It's a little more, you play mind games with someone and you bend them to your will. Here you really have to torture someone or neglect them to the point where it's effectively torture. Lock them away somewhere and deprive them of food and water till they sign the will. So that's an important difference to note. There's probably my favourite quote on page 61 from Wingrove and Wingrove, which is admittedly an old case, but in there the judge says, to give some illustration of what I mean, a young man may be caught in the toils of a harlot who makes use of her influence to induce him to make a will in her favour to the exclusion of his relatives. To be undue influence in the eye of the law, to sum it up, there must be coercion. And it wasn't in that. There wouldn't be in that case. So I just love the expression, the toils of a harlot.
I often have a situation where I get people who come along to me wanting to have their will signed. We have three JPs in a single environment there. So we're quite primed to sign wills all the time. And we have people come in that don't speak English, coming with elderly ladies, coming with their 20-year-old daughter, have no idea what they're signing, have no clue of what they're doing, and yet are being told to sign it. It's incredible. It happens almost once or twice a week. It's literally it's insane. So when I hear that the courts don't take much relevance to that, I'm absolutely flabbergasted. I really am.
Yeah.
It's one of those things. It's so widespread, it's not funny.
Yeah, and I think this is one of those areas where you scrape the surface and you get all kinds of things going on that basically the system ticks over and the system does its best to keep going. But when you think, and there's been a few Law Reform Commission inquiries into succession law in recent years, there's been quite a lot of changes where a lot of the stuff about giving courts more power to change wills came out of, because there was all kinds of abusive practices. And there's very rarely any proof. Generally, when these sort of things happen, the first things the relatives know is when the will gets put into probate, and all of a sudden they find out that they're not getting anything, and that someone else who's come along after the scene. Cool. See you later, Edward. Who appears later in the scene, has suddenly inherited everything. Now, of course, the classic example of that is marriage, and the classic example of where there are big fights is someone who has a family, we'll say they're male because they often are. They divorce their wife of 60 years, they marry a 20-year-old trophy wife, and then they've left everything to them. And they cut the rest of the family out of it. But as you said, there are situations where you're not entirely sure, where where you don't have access to proper translators. Where you've got family members acting as translators. And this happens in criminal law all the time too. We have it with clients, and a family member saying, "Oh yeah, I'll translate for you," and you're thinking, in an ideal world, you wouldn't have a family member translate, but these clients are not going to be able to pay to have a professional translator.
Yeah, the elderly guardian must have their work cut out for them all the time, I reckon.
Yeah.
The organisation, they'd be like off their feet, I reckon.
It's pretty tricky, and sometimes you've got the situation where someone cuts entitled relatives out of the will, and sometimes you've got relatives who are scumbags, and then someone else, and particularly with older people, they've got a carer who comes in and looks after them the last 20 years of their life because their family don't want to know them. They leave a gift to the carer, and then the family come and say it's undue influence because this person isn't even a relative. How come they're leaving all this money to this person? They must have in their role as a carer, got under their skin and changed their mind and made them change. So it's distressingly commonplace. So if you're going to go undue influence, you've got to basically show torture. And there's no presumption. In some areas in equity, there's a bit of discussion on 63 actually. Some places in equity you can presume undue influence, where you have, I don't know if it's not just fiduciary duties, but you've got someone who's in a position of trust, like a guardian, and in equity you've got to then prove that you weren't exercising undue influence. That doesn't happen here. There's no situations where it's presumed. I don't think it's very useful, and I think the book itself says that these cases don't come up very often, and there may have never been a successful fraud.
I'm not sure actually.
Yeah, or there may have not been one in 50 years or something. But they're very, very rare. They're very, very hard to prove.
Yeah. It's really hard to prosecute under Section 194 of the Criminal Code too for false and misleading documentation. I mean, that's the same principle. I mean, it's so hard to sort of like to prove that they knew what they were signing was not true, and in that regard, it's so commonplace to sort of like be caught up in the situation. It's ridiculous. It's really quite hard to show to make a case for it.
It's difficult, and it's one of those things where your file notes and your documentation are so important. And even things that don't seem like evidence, like you wouldn't write down that you had a weird feeling about a client. You'd find a way of saying it that sounded a bit more objective than that. But even those kinds of things can become important later on when you can produce file notes that say, the person who interviewed said that they were concerned and they wanted to further proof or something. That can actually be produced as proof. I found it says there's been no incidences of undue influence succeeding for at least 50 years. So,
okay. Wow. Very hard to prosecute then, isn't it?
Well, I think what you'd probably end up using is, and we haven't covered this yet, but there's family provision sections, which is where you believe you are entitled to or need be protected or have a gift under the will. So rather than trying to strike the will down, you'd say it's a valid will, but I'm putting in a counterclaim under that section. That's probably why those sections were introduced, is because this stuff is so difficult. So if the new trophy wife gets all the money and everyone else gets cut out of the will, you could try and prove it was undue influence, even though this may be the toils of a harlot. Or you can say, let it go, but I'm putting a claim under the provision sections for the money I need, which should end up with the same effect at the end of the day, I would think. And the other problem is when you strike down wills because of lack of capacity, is you then end up in intestacy, and that you may not be any better off in intestacy, depending on who you are. And we cover that in a whole week, and there's all rules that you follow in terms of what happens. But you'd have to look seriously at what happens if we make the will invalid, and it goes back to either number one, a previous will. That could be interesting. Or it goes under the rules of intestacy, which of itself may or may not get you what you want.
Okay.
Fraud, there's a little bit of discussion on, but it's not, again, not typically successful. There's a bit of odd discussion about common law mistake in the book, which is just confusing when you first read it. Because we now have, and it's different in every jurisdiction, we now have statutory powers to rectify wills where there's mistakes in it. So, like contract, and there's that really limited power under contract to rectify contracts where there's obviously been a typo, where there's obviously like a name that's been mistyped or whatever, and it's very, very limited. I mean, I haven't taught contract for years, but I remember mistake is one of those things that you can't just say it's a mistake. There's a whole lot of tests. Well, technically that stuff needs to apply for wills, and there's common law stuff. Forget about it, because there's now the statutory rectification powers. South Australia and ACT have one set, the rest of Australia have another. It's worth having a read through those. Again, it's that freedom versus paternalism thing is coming up again. But if you read something and there's clearly been an apostrophe that's been missed out, or a plural that's been missed out, or a name that's been misspelled, or those sorts of things, that's what you can make an application, or the executor can make an application to have the will changed.
Okay.
So again, this is stuff that it's important that you read and understand, but I don't think it's all that. You just need to know it's there. I don't think it comes up very often. The last part that probably should be included in this chapter and it's probably relevant to your work, is the new chapter 4 in the book, which is statutory wills for people who don't have capacity. And that's a very quite new, 90s, I say new, in the 90s. It was after I went to law school. A set of changes based on some Law Reform Commission reports where the courts can basically order a will if they have enough information on what a person's wishes are, and they can give effect to them. So there's sort of two themes in there. One is where someone has capacity and they've lost capacity and the will's probably invalid. The courts can actually go in and say, okay, but we think this is probably the kind of will they would want to have made had they got capacity, and we'll go ahead with that. How they do that is a really interesting question.
Yeah.
The other one is where someone has never had and probably will. Either they're a minor and they don't have capacity, or they suffer from a disability that they're never going to have capacity, in which case you can basically get a court-ordered will. And it uses the same mechanics, but it comes down to sort of a different thing in practice when you apply it.
Just reading a case, I just had a case up before in which, what was it? It was a solicitor who was taking a will from a dying man, and the man made a smudge on the will to indicate a signature, but it was invalid because the solicitor was negligent for failing to sign it, whereas the court ruled that he could have signed it. What was that? Do you remember that case?
No, I don't remember that one.
Okay. I don't know, I can't find it. I just had it.
A lot of people don't have difficulty distinguishing a smudge from their signature anyway.
Anyway, yeah.
So anyway, have a bit of a look at the statutory will stuff.
Somerville versus Walsh, that was it. Somerville versus Walsh. Solicitor attended bedside. The client badly burned a house fire. Will was made, and he couldn't sign it because he was badly burnt, but he made a smudge with his bandage, but it didn't actually constitute a signature according to the court, because the solicitor had the power to sign on behalf of his client, and because of that the will was factually invalid. So yeah, that goes, yeah, okay, I see that.
Is it an old case?
Somerville versus Walsh, yeah, looks like it. Just trying to bring it up. It's mostly really bizarre. 1998?
Oh, not very old at all. Okay.
New South Wales. Anyway, with those tutorial questions, I actually had a go at the first one of them, and
Yeah.
that was on the notes that you had. The first one had to do with Section 33 of the Succession Act, in which the court has the power to sort of. Where is it? Yeah, the court has the power to sort of change the will if it wasn't what the court held that was within the wishes of the person that had died, and because of anything from a mistake to fraud to a clerical error, or it wasn't in line with what the testator wanted. So the court has the power under Section 33, and the question was that the testator left legacies to each child of his son's wife, but the children from a previous marriage, and it looked like it was a technicality. He stated that they were sort of like his children, but they were, well, his stepchildren. So it was a printed mistake. So the question is asking whether it's going to be valid or whether it's going to be treated as a simple printing error, or so to speak. Now, the courts would apply in that instance the principle of Siegelman and ask those three common questions as to whether the testator's intentions were in line with what the testator wanted and whether the rectification would be justified. And secondly, whether the will would be clear enough to have expressed what the testator wanted. And third, that it was nothing more than a simple error. And that's the way I interpreted Siegelman. I don't know if I'm right or wrong, but that's the way I came to that conclusion. And at the end of the day, it probably would be valid, because it's clear that the man would have wanted the legacy to go to his children rather than his stepchildren.
Yeah. I'm not sure what tutorial questions you're talking about.
Okay, is that the end of the
Yeah, they're the stuff that I left it in there for revision purposes.
Oh, okay, well, I've just done them anyway. I thought
Yeah.
I'd go through them.
Yeah, I mean, it's good,
didn't know whether we had to do it or not, but
good to check your knowledge on it, but they're not the accessible ones. They're just
yeah, no, I just wanted to have a go to see if I was on the right track or not, just to sort of like get an understanding of whether they were coming from. But I couldn't do problem 4. I'm not going to do that one.
Let me have a quick look. I mainly didn't, because I'm only sort of taking this subject for one term. I didn't want to take out the stuff that was already in there. So I added my workshops onto the top of it.
Yeah.
And I thought they probably are, if you're going to work through them, useful for you to have a look at. Okay, problem 3. Yeah, see that changes a lot once you figure in the statutory wills too.
Okay.
A lot of the case law now, if you've got a will that's invalid or you've got lack of capacity, through lack of capacity, the courts can come in and make one up for you.
Okay.
Which I feel kind of ambivalent about. I understand the need for it.
Yeah.
But when you look at the provision, it says they can take into account any evidence of the wishes of the person, the likelihood of them ever getting capacity back, terms of previous wills, size of the estate, and any other facts that you consider relevant. So basically,
what section of the Act are you reading from? What part of the Act is that section?
I'm reading from the textbook. Actually, it's
okay. All right.
On that page 92. It's section 7 for the South Australian.
Yep. Okay. Yep.
And the others are relatively similar.
Yeah.
But basically, it goes from the original kind of ironclad, the will is the will, almost a constitutional approach to the will, to basically
a legal formalist approach. Yeah.
Yeah. So now you've got a situation where you can go, oh, well, look, we think this is probably the kind of will they would have wanted. And I'm sure the judges don't take it very seriously. I'm sure they don't do it for
No.
But we're going to talk about cultural difference and stuff in a couple of weeks' time. And that's where I think you're presuming a lot, to presume that if a judge says, well, I think this is the kind of will they would have made, well, how much do you understand that person's culture? How much do you understand the way in which they, do you really understand what they would have done?
Okay. Okay, well, it's definitely 7 o'clock now. I'm going to have to get going, make my dinner, go to bed. I've had enough. Had enough for one day.
That's cool. If you have any questions, as usual, you can drop me.
Yeah, for sure. Absolutely, yes. Thank you.
Okay. I'll catch you next week.
Okay, see you next week. Bye-bye.